change is coming. Rules are coming. And what the Department of Justice, Antitrust Division, my former employer, and these plaintiffs' counsel around the country have said is that we need to think about consumers more in setting up the transaction of real estate. And so here we are, fast forward several years, and change is finally here. Took a big jury verdict, about $1.8 billion against NAR in one case. And this is the result of that, is finally coming to the MLS fields, where essentially at a high level, the system is becoming less efficient.
Hey everybody, it's Matt Fowler at Triangle MLS. I'm the executive director. This is our most recent edition of the podcast and a really interesting one. I know that everybody is going to be interested to hear what our guest has to say today. We have Dylan Carson, who I'll let introduce himself. I met Dylan a couple of years ago at CMLS, but he's going to be joining us in September at our PropTech South event on the 19th. Dylan, welcome.
Thank you, Matt. Good to be here. My name is Dylan Carson. I'm an antitrust lawyer. I'm the outside antitrust counsel for Triangle MLS, and I'm excited to share with all of the attendees at PropTech and all of the listeners at the Triangle MLS podcast the many exciting changes that are coming to the world of real estate, and courtesy of the antitrust laws and enforcement by both private plaintiffs and the Department of Justice. There's a lot to understand and a lot to learn. So it's going to be a great session.
Thanks, Dylan. We do have so many questions. And this, you and I have talked about this, over the past year. I guess we've been talking about compensation in the MLS together for a couple of years. Now we have this settlement. We had all those lawsuits. I know Larson Skinner was tracking 11 or 12 or something for us. And what I'm trying to get out in the podcast today, and what we're going to talk about at PropTech South on September 19th, is trying to bring this down from, the legal language and the statements of don't do this, don't do that, of 10,000 ways, to something that explains what this is about a bit more to our subscribers. What is exactly changing? There's some big changes, but in a sense, we're moving a field from one kind of piece of paper to a different kind of piece of paper. It's not going away. We still expect buyer agents to be paid for the work that they do. Triangle as an organization believes that representation is valuable. I think a lawyer would probably agree with that too. What's worse than an unrepresented client? The deals go better when there's experience on both sides. And the point is not to discount that or to, certainly to prohibit or eliminate that. That's not what we're talking about. But in the past, the courts have pointed out and have been successful in pointing out that the payment of buyer agency services across the country is not consumer friendly. And I'll leave the definition of that, to other documents. But what we're doing very clearly, and we're going to kind of get to the meat of that really fast in this podcast, is on August 6th, we're taking the fields out. August 17th, we'll begin enforcing those rules. The rules are going to be finalized this week and published before all this takes effect in around the 1st of August, before this podcast comes out. So what we're going to be doing is making sure that brokers and participants and subscribers, brokers and agents, are not putting it somewhere else on the MLS that would be inappropriate. And then we have this other requirement that we're responsible for demonstrating to the court that buyer representatives have a signed agreement with the buyer prior to touring the property. Touring, according to us, is any live in person or any live video or virtual tour of the property. Anything that meets that definition has got to have this document. And in North Carolina, we've had this requirement for a while. So maybe tell us a little bit about those two requirements, Dylan. I think taking things off is pretty straightforward. But what if they, one question that we often get is, where do I put it now? Right? It's not in the MLS. Well, where do I put it?
Right. So to step back, I think, Matt, we've been talking about this for years. I went to the CMLS conference, and it felt like in the middle of COVID, and said, change is coming. rules are coming. And what the Department of Justice, Antitrust Division, my former employer, and these plaintiffs' counsel around the country have said is that we need to think about consumers more in setting up the transaction of real estate. And so, here we are, fast forward several years, and change is finally here. Took a big jury verdict, about $1.8 billion against NAR in one case. And this is the result of that is finally coming to the MLS fields, where essentially at a high level, the system is becoming less efficient, which is ironic because antitrust law is all about making things more efficient. But here, without the ability to communicate compensation in the MLS, in any field, the compensation fields are going to go away, and you can't try to sneak in compensation in a different form. No wink, wink signals. You can't put it on a Post-it note in a photo. You can't put it in the showing time instructions and the agent to agent remarks. You can't embroider a pillow and leave it on the couch in the video tour.
We saw
put it on the fridge.
We saw refrigerator magnet letters
Right.
the other day. That was
Right.
pretty funny.
No percentages, no dollar signs. You got to pick up the phone, right? What DOJ and the plaintiffs have expressed that they want to see and that they think has been lacking in the residential real estate industry for years is negotiation over amounts. So on the seller side, you can't communicate it. You can put it on your own website, but as a broker, as an agent, but you can't put that information into the MLS. You can do your own advertising off of the MLS, but we, Triangle MLS, cannot be part of the communication of offers of buyer agent compensation because that's what the settlement says at a very high level.
Let's crack that one thing open, and we're going to talk about this a lot more at PropTech South on the 19th. The afternoon is kind of set aside to stats in this particular session with Dylan. So in our private remarks field that's common in the MLS system, we're going to be monitoring that and very closely for the use of words like commission or compensation or percent signs or things that lead us down that road, and that's a violation of the settlement. You can, however, link out to a company website on that particular listing where the listing detail page can be displayed, showing the price for that property, all the pictures and the details and stuff. And if there's a button on that page that links you to a second page, you can put compensation on your website as yourname.com. And it's super easy when someone wants to know what the commission is going to be or the compensation is going to be offered on that particular listing. You go to your website and look at it. It's right there. It's one click off. So is my understanding, someone couldn't sit in front of that website and click next a bunch of times and be able to easily know what the commission was on all of those listings. They're making us make that a bit another step into that. So those things are illegal. There are websites out there that are currently selling their services to my subscribers where they're saying, come to this other place. It's illegal on the MLS now, but you can share commissions out here. And our position on those is that we don't endorse or approve any of those, but our opinion on them is that as long as the commissions or compensation is case by case basis, and it's a one at a time, a buyer goes and asks and they get a specific answer about that property, then I don't think that's outside the bounds, but I think it's necessary because you can do it on your own website and publish the commissions there.
Yep. The NAR settlement specifically contemplates that there is freedom of contract here in the United States and that agreements to pay buyer agent compensation can occur outside of the MLS. They just want to get us out of the business allowing agents to filter listings based on compensation being offered, because what they're at a very high level, what the concern of the antitrust enforcers and both the public and private enforcers is that has resulted in steering, and that folks who did not offer high enough levels of compensation, then those houses wouldn't be visited.
Yeah.
and that they were, agents would filter them out based on how much buyer agent compensation was offered, and then there wouldn't be any negotiation with buyers over how much compensation the buyer agent was getting.
Right.
And so this is an attempt to kind of address those concerns. But there's still this important kind of concessions field where I think, and correct me if I'm wrong, Matt, Triangle is doing things to help brokers and agents and their clients, because the NAR settlement expressly permits that sellers can offer buyer concessions on closing costs. But in that concession field, it can't be only limited to buyer agent compensation.
Right. What we've elected to do on August 6th, at least at the outset of this, is to remove the buyer agency field and not to add the seller concession field as specified or allowed in the settlement. We know that some other MLSs are doing it partway. An adjacent MLS to us has decided to add the seller concession yes no checkbox. So we're just saying that they're saying that there are concessions on this listing, and finding out more about that, as you said, would be a one-to-one case-by-case conversation that the buyer rep would have to have with that
Yep.
with that seller rep, and that's the intention of the settlement, as I understand it.
Yes, it's a brave new world. There's going to be a lot of trial and error in this first kind of phase of when these changes go into effect all over the country, and the hundreds of MLSs are around. There's going to be, I think, some sharing of information publicly to say, here are some best practices. Is this allowed? Is this not allowed? Reading between the lines in this settlement agreement, what is kosher, what is not? It seems pretty clear that you can't just move the compensation field into concessions. You can't just create a replica field to say, oh no, I just put it somewhere else.
Well, we were clearly concerned about that happening at launch when everything's super confusing. Having a new field that says concessions on it, that feels too risky to me at launch. And notably, California Regional initially said they were going to have it. Now they've pulled that back. I don't know the right thing for our subscribers. We're watching all of this and talking to learned counsel like Dylan and our friends at Larson Skinner and lots of different people about this, trying to kind of thread the needle and make it well within the spirit and language of the settlement, but also keep commerce moving.
Right.
We had 63,000 showings last month. So this is something that has to work at scale. And I want to, before we move to buyer agency and wrap this up, as we get ready to talk about this so much more at PropTech, Dylan, I'm thinking about and Chris, another attorney, and I were talking about this the other day. I'm thinking about 2 years from now. Okay. So the DOJ, the court system, has made us do these changes. And I think they're going to want to know if it worked. And they're going to know if it worked, as I understand it, and help me with this kind of just existentially here. They're going to want to demonstrate that there is variability in the payment of buyer agency services, that competition has come into the marketplace because of the removal of this kind of setting of what it's set to be in the MLS. That's gone. So now there should be a lack of consistency in that number. If you look at it over the past, it's remarkably consistent across markets. That's one of the arguments that the courts found compelling. How do you see that? I don't know. Now that it's not in my system, I don't have any visibility to it. So I can't tell them if the settlement is worked or not. There are offer management systems. There we go. That Triangle is contemplating that would be off MLS. They're inside, the envelope of the deal. They're encrypted. No one can see them. So there is no network effect or statement or visibility of that amount. It's simply a number that, goes from the buyer encrypted thing to the seller's encrypted thing within the offer management. That brings, using something like that would bring some order, some guardrails, a rules-based system, but as importantly, a reporting mechanism that Triangle could use specifically for the regulators to show them across the marketplace the effect of the settlement on the variability in the payment of these services. Because if variability isn't achieved, I don't think this is over. And I think they'll want to attack it a different way. Am I looking at that correctly?
Yeah, I think directionally, yes. How do you, if DOJ's goal is to see the effects of competition injected into the marketplace, then how do you measure that? Right? If economic theory would tell us competition leads to lower prices and more competition for services and consumer benefits, then
Mm.
how do you measure whether prices have come down and rates have come down for both seller agents and buyer agents
Mhm.
over time? And if we, the MLS, don't capture that information, then how are we going to be able to report it to anybody? That's one of the ironies. If DOJ were to come to us and say, "Hey, give us all your data on transactions so we can understand whether buyer agent commissions have come down," we'd have to, throw up our hands and say, "We don't have that info.
Sure.
You'd
Sure.
have to go talk to all those brokerage firms."
And you'll
Uh,
have to, I guess, audit them one at a time and pull it out of their IT systems or worse, their Gmail inboxes. Um,
So that might be one of their goals overall. My friends at DOJ, that might be what they're after. Nobody knows.
mm,
So competition should be working. If in theory it works, then there will be more competition over the buyer agent compensation. They'll
sure.
have buyer brokers saying, "Hey, I'll represent you for less. You're going to pay me X instead of Y, and I can do it better." And one of the upsides is that competition should bring out the best in agents and their ability to
Sure.
make their clients happy. And from DOJ's perspective, the amount of service and the quality of service you offer
Sure.
to a consumer should be reflected
Sure.
in what you receive, what kind of compensation. And their concern today is that there's no connection between the amount of compensation that an agent
Sure.
makes, what the effort is that goes into buying or selling a property.
I think some of us get that anyway. It's not the number nailed on the wall anymore that you can kind of hide behind. It's something you're going to have to work out on a case by case, one at a time basis. Yeah. So this
So
is
yeah,
obviously an enormous subject, Dylan, and it's going to start in August, but this is going to be going on for the rest of the year. No doubt the information that we'll be sharing with people on September 19th will be different than what we covered today because we'll know more. The rules will have been implemented different ways around the country, and we will, almost certain it won't stay the way it is in August, forever. So, just in our last maybe minute left, we have this other requirement recording related to buyer agency. It's a little bit easier in North Carolina because we've had that requirement for a while. And Triangle sort of looks at this as like the seller agreement. We don't require our participants to produce those unless requested. So the buyer agency requirement has been in place in our rules for a while. There's some additional language around it, and there are some now penalties associated with being unable to produce that document if requested by the MLS. And, we'll be doing that work in terms of maintaining the requirements under the settlement that we have to demonstrate to an official that comes to town one day that we have an aggressive policy and action to implement this settlement. And I think that we can demonstrate that with the commission that we just discussed and also with the presentation of these buyer agency requirements. Do you have anything like additional related to the buyer agency agreement in particular that you think is interesting for people?
Well, it sounds like North Carolina is ahead of the curve nationally as far as that requiring agreements before showing homes, touring either virtual or in real life. The what the settlement requires is bold, conspicuous language
Right.
that commissions are fully negotiable, not set by law. The one thing I'd add is if a client says, don't show me a house that offers no compensation, then you can still have that conversation with your client. And you're going to have to do more legwork and find out kind of what is available in the market. You just
Hmm.
won't be able to use the MLS to make that decision. And none of the information on, as I understand it, under the buyer contracts, listing any kind of compensation, which has to be very specific and not open ended. It can still be a formula or percentage, but none of that is submitted to the MLS, as I understand it, unless there's some kind of investigation and there's a
Yeah.
claim that maybe someone
Right.
isn't isn't following through. And then I don't know if there's a plan, you probably know better about, some kind of auditing or some kind of mechanism to make sure that the rules are being followed. But yeah, it's late July now. We're going to be on the stage in mid-September. It'll be a work in progress. So we'll have some results from the national experiment to discuss about what's working and maybe what isn't working. So definitely a timely, an ideal time to attend Prop Tech and know what's going on in the cutting edge in the industry.
It really is, Dylan. Thanks for the time today. We really appreciate it. Providing a little guidance to our participants. One of them said at the meeting yesterday, "Hey, onward through the fog. Like we're just uncertain, but we're moving, and we're going to help as much as we can, bringing some experts to town." Again, thanks for the time today, and thanks for coming to town in September.
Great. Thank you, Matt. I appreciate it. I look forward to seeing everybody.